This is the fourth video on contract law cases. Again, here also we'll be focusing on a number of important cases to cover these topics like misrepresentation, implied terms, and of course, exclusion clauses. These are all important areas uh, at any assignment or an exam. Let's focus on the first one. The case is Derry versus Peak. You can see the picture. It's about a tram, steam-powered trams. Those are the vehicles that were common even in Colombo. We had the tram cars about nearly a century ago, I think. So there was this company which says that they have the permission or the license to operate trams. So believing that investors purchased or bought shares of the particular company, thinking that the company has a license or has got the license to, operate a tram service in the city. That's what the company stated. However, the court said there was a misrepresentation because company has actually applied for tram operation permission, but they have started asking people to invest for shares before the company got the permission from the local authority to operate trams. Actually, the local authority never gave them the permission. So when the investor took legal action against the company, the company stated that they justifiably believed that they would get the tram operating license, that they were not fraudulent because they also applied for it. But here the court said there was a misrepresentation, although it was innocent and not fraudulent. So still, the company was liable for giving a false statement of fact, although they did not intentionally do so. They thought that they would get the permission, but they didn't. And the court said that's still enough for misrepresentation, giving wrong information. So when you give wrong information, the other party can stop the contract. And yes, you can demand compensation, as in this case. This one. What happened here was there was a lawyer who exaggerated his practice. Normally, we boast about our practices, right? Our stuff. It's a normal practice. So the lawyer also, when a client came to him, he boasted about his practice and how many cases he's handling, how much money he's making, and how many courts he's going to, etc., etc. But later, he found out that this particular client found out that the lawyer was actually not telling the truth. Then the the client, right, the one who came to get his services, wanted to stop the contract and he wanted cash back. He said, I believe that you were telling me the truth, but you are lying all these boasts. Believing your boasts only, I decided to use you as my lawyer. Now I know that you lied, so I want my money back. And the lawyer refused. Lawyer said, then this is the normal process of a lawyer, right? We do basically boast a bit, but the court was not willing to take it. The court said that, yes, there is boasting, but that is misrepresentation. You can't say it's fraudulent because every lawyer is boasting, right? But in this case, the court said this is innocent misrepresentation, not fraudulent, but still, the court said that the client could stop the contract because whether the misrepresentation is innocent or fraudulent or careless, still it's misrepresentation. So it's a learning point for a case for professionals, right? You cannot give wrong information, cannot boast, right? You have to be factual in providing information to a client. So here, the client was able to stop the case and stop the client services from lawyer and get the money back as well. This one, the Moorcock case. What happened was the ship was anchored by the jetty, like in the picture here. And once it was done, there was a rock below the waters near the jetty and it damaged the ship. Then the ship owners took legal action against the harbor. The argument, right, we expected the jetty to be safer for our ship. It wasn't the case. There was a, protruding rock underneath, the waters, damaging our ship. So it was your duty to keep the jetty and the nearby area safe. I mean, the concealed rock was the one that damaged the ship. The other, the company or the harbor tried to escape liability, telling, cannot be blamed for that sort of a thing, right? But there the court said no. Whenever you give permission for a ship to anchor up by the jetty, it's implied, that means it's automatic, that the general safety has to be ensured as well. In this case, the harbor was careless. They haven't done the homework on checking the safety under the waters. So there the court stated, yes, there's an implied duty of safety, and that duty was broken by the harbor, so the ship was able to file legal action and win the case. This one, it was a case of, an apartment complex in Liverpool, UK. Tenants took legal action against the the building owner for not keeping the staircases in proper condition. And the landlord stated that, no, that's the duty of the tenants because I've already rented it out. But there the court said, no. When you are the landlord in a building, it's the duty of the landlord to keep the public areas, that means the areas used by everybody, in proper condition. Your failure is a violation of a key condition of safety. It's an implied term, the court stated. While the tenant may be responsible for his rooms, his flat, the apartment, but the public area in the building is a duty of the owner of the building because that area is not rented out now. So the court stated it's an implied duty. So what's the meaning of implied duties? In the Moorcock case, as well as in here, we learn, we call them automatic duties. Whether we have it in the contract or not is irrelevant. It's expected that a party to be reasonably understanding their implied duties. That means the automatic duties, like, protecting the waters underneath the jetty. Here, taking care of the staircase. You don't have to have it in the contract. It's your duty to do so. That's when you're implied. This one is Lestrange versus Grocom. Now, signing a document is not an easy thing. It's an easy thing to do, but not an easy thing when it comes to liability. In this case, someone signs a document without reading the terms above your signature, and the court said you're liable for the signature. After signing a document, you cannot say you are not liable to the document, because signing a document means three things. That means I fully read it. 2, I fully understood it. Third one, therefore, I fully agree to that. That's the legal meaning of the signature. After signing a document, you just can't say, I didn't read it, I didn't get the chance to read it, I couldn't understand the language, or I was in a hurry. None of them will apply. You sign a document, you are in trouble. You are liable to the document. Here also a pretty similar case, but there was something different here, right? There was this person, 1971, recent case, right? He parked his car and then he got a parking ticket. And the parking ticket had a term which stated that if the driver is injured in the car park area, the city council would not be liable. Okay, you can park the car, but the city council will not be liable for the damage to you or the car when you are in the parking lot. Now, in Sri Lanka, we have it, right? They say parking at your own risk, like, or we are not liable for theft or anything. Normally, the car parks near supermarkets have this notice telling it, right? So here, the parking ticket itself, there was this term telling, if you are injured or if your car is damaged in the parking lot, we are not liable. But the court said, no, that is an unfair term, and it was printed in the parking ticket. So just printing it is not enough. You have to inform the party about this term. We call them exclusion clauses. Exclusion clause is a term where one party says he is not responsible. So literally, the Keel's notice. Okay, imagine that you park your car near a supermarket in the parking lot of Keel's or Apico or Cargill's, right? And all these places say that they are not liable for damages to the car in the the parking lot. There's a board telling it. But legally, such a board is useless. When you park the car, the parking attendant must personally come and tell you that they are not liable for the damages caused to the car. That means someone stealing a side mirror or something, or one car coming and hitting another car in the parking lot, something like that. But let's say if you have a parking lot, if you don't want to be responsible for certain kind of damages, then you have to inform each and every driver personally. Just hanging a board will not do. So Keels or Cargills or Apico cannot win the case if something like that happen inside the parking lot. Automatically they will be liable. If they don't want to be liable, the fact that they are excluding liability of from a particular aspect should be informed to each car owner, each driver separately, person to person. That's the thing, the important case. This one. It's about, there was this contract, and the contract clearly stated exactly when the payment should be done. Exact date was there. Normally in business contracts, you may see them. In this particular incident, the man who took the leasing agreement, failed to pay one installment. He was a bit delayed. And that was enough for the leasing company to cancel the contract. Then the man went to the court and said, Your Honor, I've been doing it. I've been paying correctly. Only one time I failed it. And this is it's wrong for the company to cancel my contract and demand compensation. But there the court said the terms are clearly stated in the document. Very, very clearly. Nothing implied, very explicitly stated. You broke one such term, that means paying not on time. The court stated that you are liable. So if the terms are very clearly mentioned in a document, in a contract, it's highly important that you don't break it. So whenever you sign these, what you call these leasing contracts, insurance contracts, loan contracts, hire purchasing contracts, read the document very, very carefully. A failure to follow a specific rule, term, included in the document may result in the other party getting the right to stop the contract and even to damage compensation for it. It's a very recent case, 1987. This one. It's about making a beer. I go to a seller, and I ask, the hops means, the kind of a plant-like thing you need to make beer. In the beer making process only, you use these hops. I haven't seen it. I haven't only heard about it, right? So they are the buyer of the hops. He wanted to buy hops to make beer, brewing purpose, right? He asked the seller whether this particular hops, the plant, has been, kind of added with sulfur. And the seller said, no, nothing to worry. We haven't added any of those things. But later it was found that the seller had lied, right, to an inquiry made by the buyer. And the court said, but trusting him only, the buyer bought the hops. And he found out that actually it was contaminated with sulfur. He was added with sulfur. But seller said, no, he did not do so. The court said, this is misrepresentation. Actually, fraudulent misrepresentation. Court was able to order compensation. This one, take a look at the crankshaft. So what you hear is a crankshaft, right? So there was this factory, a mill, right? And the mill had to stop operations because the key crankshaft of the main machine was broken, had damaged. So then the owner of the mill, the one who owns the mill or the factory, gave the crankshaft or the broken crankshaft to a repair person and asked him to repair it and return it, right? So, but the repair person took such a long time to repair it and return. And all this time, the factory was closed because the crankshaft was not there. And then the owner of the factory, that means the one who is the proprietor of the factory, took legal action against a crankshaft repair person. Case was, I gave my crankshaft to you to get it repaired within a reasonable time, and you took such a long time to return it after repair. All this time my factory was closed. So you have to pay me money, not just for the delay in returning the crankshaft, but also for the loss of profit because of the closure of the factory, both the things. But there the court said no, because this particular crankshaft repair person did not know that the factory was not operating without the crankshaft. The owner did not tell him that. Owner just gave him the crankshaft and asked to repair. He did not tell him about the consequence that happens because of the unavailability of the crankshaft, that the crankshaft was, essential to run the mill, and now the mill or the factory is not operating. That particular fact, the owner did not tell, nor did the repair person aware about it. So there the court said, of course, for the delay, the repair person should be liable, but not for the closure of the factory because he did not know that. He could not foresee that. So under contract law, you are liable for the foreseeable loss, not every kind of loss. The loss that you can reasonably identify as the loss that may happen because of you, right? So other party cannot make an unfair amount of compensation demands. The compensation that the court would agree would be a reasonable loss, that the loss of which he was aware of. So that's it with regard to key cases. This is a fourth video on contract law cases. Take a look at all four videos, and as I've said it in a previous video also, always tell the story when it comes to contract law. Not just the contract law, but contract law makes really good stories. So whenever you do an assignment or a report or a presentation or whatever, to clear out certain points, always come up with cases and describe the case with very simple language. Just 3-4 sentences can easily clear up a very good story. Catch you in another lesson.